I love the theme of this conference, valuable data, priceless privacy. I've been talking since my appointment 2 years ago about treating privacy as a fundamental right, about ensuring that privacy is not an obstacle to the public interest and to the private interest, and that doing this generates trust. And I think this is, we've heard some remarks so far about how it is important and that we can achieve public interest and private interest while at the same time protecting the fundamental right to privacy. And I like to frame it slightly differently sometimes to say that, in fact, we can achieve public and private interest by protecting the fundamental right to privacy. I think privacy not only is it not an obstacle, but actually is a tool, and it helps reinforce our objectives elsewhere. It is a challenge. It requires work. The challenge is becoming more complex as have been hearing and will be hearing about fast-moving technological developments, evolving laws, the presence of incentives to use data, incentives perhaps sometimes to protect privacy less, and that's something we have to be aware and work on as DPAs. Multiplicity of jurisdictions, sometimes even within one country. In my country, Canada, we have provincial legislation, we have federal legislation, we have then, of course, international overlapping regimes within countries, outside of countries, and sometimes gaps. And so the topic of this session is, what do we do as DPAs working with other regulators and also with other organizations? The OECD, very active in identifying some of these challenges for organizations. OECD's published interesting work on challenge of DPOs and law firms in this space, and in the context of international data transfers and the patchwork of regulatory regimes causing challenges. And they've published recently on cross-regulatory collaboration. And to me, this is the theme that it is not a zero-sum game between protecting the fundamental right to privacy and achieving public and private interest. And it's also not a zero-sum game, and should not be a zero-sum game, between protecting privacy and other legal regimes, such as competition, such as broadcasting. Just to list some of the areas in Canada where we see potential overlaps, and I think that's true elsewhere. We see it with competition. We see it with copyright, certainly in the world of AI. We see it with broadcasting, with some broadcasting regulators being required to promote certain content. In my country, it's promoting Canadian content, and so that touches algorithm, that touches privacy. We see it in the world of equality rights, and we know that, and thank you, Colin, for mentioning the Declaration on Privacy and Democratic Rights. But privacy is an essential element of other fundamental rights, including democracy itself, including freedom from discrimination, the right to associate, and so on. And so we're seeing these overlaps again with the world of AI. Lots of focus on what goes into AI, but what comes out. And what comes out can be bias. What comes out can be harmful effects. And so we see this overlap there. The role and the protection of children, one of my priorities, raising issues of age verification. And how do we protect children online while at the same time not sacrificing everyone else's privacy. We see it in the world of finances and banking. Fight against money laundering and terrorism financing raises issues of how banks can share information with law enforcement authorities, but also with other banks. And so recently in Canada, there was an amendment to our rules that would allow banks to share information with other banks within a framework of a code of practice that would be approved by my office. And so this is an example where found a way of protecting public interest, but not sacrificing privacy while we were doing it. We see it in the world of national security, disinformation, bill before my parliament in terms of creating a foreign agent registry, given concerns about foreign interference in Canada's election. So that raises privacy issues. Colin mentioned democracy, the regulation of political parties in my country. That doesn't fall under my remit, but there are legislative proposals to increase obligations, not enough in my view so far, and have the electoral authority consider those to be violations under that law and under potentially criminal sanctions. So there's a potential role there for my office, certainly if I'm not going to be the decision maker, to be involved in setting those rules and to be making submissions before that body. We see it in the world of cybersecurity, and we see it in the world of AI. So there are overlaps, there are potential gaps. What are we doing as DPAs? We're working already very closely in Canada with the provincial counterparts. We have a number of joint investigations, including one on OpenAI, one on TikTok that are underway. We do it internationally. Recently, John Edwards and I announced our joint investigation on 23andMe. We are doing it in terms of policy statements, whether on AI, whether on employment, but we're doing it also with other regulators. And so in Canada, we recently created last year the CDRF, the Canadian Digital Regulators Forum, and it includes my office, the Competition Authority, and the Broadcasting Authority, with the stated purpose of making sure that we're aware of each other's priorities, that we avoid zero-sum games, that we can increase our reach and our impact. And this year, I have been designated to chair this forum. And one of my priorities will be to have some concrete products at the end of the year, whether it's a joint statement or a joint work. And we've started work in this space in terms of synthetic media and deepfakes. And we're going to be looking at the implications of that from a privacy, competition, broadcasting, and also copyright, because we have a copyright board that has joined us as an observer. So with the goal of saying, well, are there commonalities? Are there potential areas of distinctions? Are there gaps? We've recently joined, this forum has joined the International Network for Digital Regulatory Cooperation. Very happy to be working with the UK, Australian, Belgium, Irish, France, UK, Netherlands, Ireland, Australia colleagues in this space, and we're going to be participating in November with the OECD in further discussing these issues. We're active at the GPA with the Digital Citizen and Consumer Working Group, where we've done some mapping of areas where there's intersection, in particular including on online safety, telecom, financial regulation, and AI. And we're active with the GPEN grouping of regulators coordinating activities. And we have a concrete activity, which is GPEN Sweep, where regulators will work together and will look at certain websites and on a certain theme. And this year, the theme was deceptive design practices or dark patterns. And so we've conducted a sweep with 26 other privacy authorities, looking at 1,000 websites. And we've done this for the first time also with the ICPEN from the competition side. And so we're looking forward to issuing our findings on this very shortly this month. And this is an example of looking at an issue that's cross-cutting. And so I will stop here, but happy to continue the discussion. Thank you.